Morning, afternoon, or evening. This is Stephanie Joy with Joy Disability. You're about to see a replay of the live Q&A of a recent session. They are generally 1 to 2 hours long every Wednesday at 1 p.m. Eastern Standard Time on this YouTube channel. So I hope you get a little tidbit of information out of it. Otherwise, maybe I'll see you at 9 a.m. for short little workday shares that we put out there on a daily basis. Take care. And I have that green screen up we were talking about. See, it's like I don't know what it is. Anybody have any ideas? I'm gonna get to the comments. Well, that's not fun. How's everybody been? See a bunch of people in there. Nice to see you guys. Don't understand the screen. Seriously, was not doing this before, guys. It's like my camera is being weird. Super weird. I don't know. It's cutting off my head. It's cutting off my head. It's cutting off my head. If I go like that, I suppose it's a little different. But it's just definitely distorted. Oh well, it is what it is. Let's go. Alrighty. Thanks, Deb. I see you down there. Tie-dyed shirt. Yeah, I know. I love this shirt. It's so comfortable. My son actually tried to steal it from me. I got it at the thrift store. My favorite place. Okay, so let's get to it. We've got, I hope you guys have a good week. Kevin Johnson, what does it mean when SSA says your case is pending additional development? It's been 2 years, maybe 2 or 3 adjudicators have had your files. Okay, so I assume you're, Kevin, are you still at the stage of, what are you on, reconsideration? Or are you on initial? Are you heading for a judge's hearing? It really depends on what stage you're at. You say 2 to 3 years. If you're still on initial, or if you've been that long on reconsideration, that's a huge problem. And I would be, it sounds like it fell through the cracks. I know you can't see your file to see who's last worked on it, but that's kind of a nightmare. So I would, oops, sorry, I'm still playing with this. I would maybe contact your congressperson. This is assuming you don't have a representative that would be doing it for you. Kevin also says they have not called for anything in a year. Okay. That means it's probably sitting there and you probably didn't have one, like you said, and you went through a few. Remember, there was that great resignation a few years ago, and they had a hiring freeze. Well, the federal government had a hiring freeze a couple of years ago, which is still, in a sense, existing. And although the adjudicators are state level employees, I think when the government maybe has a hiring freeze, the states are less likely to hire someone because the money they're getting from the federal government to outsource for these federal purposes is perhaps not increasing accordingly as if they hire somebody. So I don't know how that interplays because remember, the adjudicators are not, now that just weird, did something weird, didn't it? Did it just move again? The adjudicators are not federal employees. So hi, Trish Wade, good to see you. I'm having a great day, thank you, except my thing here. And it's funny, this looked kind of different before. And then I went and did a little something I had to do, which included Zoom, which included video. I did it kind of like 15 minutes before we were coming on because I'm like, oh, I should get that done. I got 15 minutes. I'm that kind of person. And I come back to this, which is a different platform. And then it looks like this. So I don't know. I feel like that had something to do with it. Makes my face look really skinny, doesn't it? All right. Lisa Gilbert, nice to see you. Pro se, 62 years old. Oops. Date last insured is December 2021. Okay, so you have a remote. I see a bunch of dates here, Lisa. I'm going to assume your DLI is old. It's like 4 years old. And then 2018 to 2021, you started up a new business, no profit, no pay, no SSA credits earned. That was a mistake, but it's in the past. There's not much you can do about that now, particularly because you are out of time to even file an amended return for 2021. That year is now scrolled off the board of what SSA will consider in terms of giving credits. You know, the IRS will always take your money, but the SSA won't necessarily give you, credits, earnings credits for it. We do have kind of videos on that and how the rule, the 315 rule, and when you can amend your return to maybe not take every single tax deduction you could take off of your self-employment business for this purpose alone. We don't know though until we know. I wouldn't have known either. All right, you have an LLC, you don't work it, so that's kind of irrelevant. That's like any other, it's almost like any other asset. And it might have zero, sounds like it has zero value. So just because it's open on paper doesn't really mean much. All right, I don't see a question there, Lisa, so I'm going to move on. And if you have a question later, feel free to ask it. Tristan Miller, Nice to see you. Good afternoon to you as well. Rat's Nest. Nice to see you again. Broke Dance Mom. Got my hearing for 8/25. Yoo-hoo. So that's cool. It's coming up. The judge assigned is ALJ Diggs, and he has a 77% approval rating. Please provide best tips to prepare for ALJ hearing. I'm nervous about the vocational expert. Okay, I do have a recent video on questions I go through, and every case is different. So there's going to be different questions depending on your impairments and your functional limitations. But there are some basic set questions sometimes that are asked, and it will depend on your case if they would or would not be asked. There are ones to flesh out positives, and they are also ones to bring out what would be perceived as a negative if it's only looked at in the paper record, some statement in there. Sometimes we will bring that out at the ALJ hearing, and I'll ask about it so that my client can tell the actual realities and all the contextual circumstances that go behind it. Because if they don't, what's going to be in the record for the judge to then absorb is not favorable. It could be an unfavorable little twang to it in terms of what it's going to portray. Even if it's only a little crumb, it's a crumb of negativity towards your case. But I did recently put out the one side of a conversation in a hearing prep with a person particularly with physical impairments, not with mental per se, and just the banter that kind of goes back and forth, although you don't hear the other side because obviously confidentiality, but the kind of questions that are asked. Instead of those questions just being in a transcript for you to have to read through, they're actually verbal. So you can look at that. It's within the last few weeks. If you just go to the channel and scroll through, I suppose. But you got a judge with a nice rating. That's super sweet. I don't have any like that. But it's probably not a bad thing because then we just do the full maximum workout possible in every single case, and then you don't ever have to worry. Doesn't mean you're going to win every case just because a guy has a low rating and you work your butt off, but you give your client the best chance possible. And if you're a client or a claimant, you give yourself the best chance possible. And if nobody else, that is your duty to yourself, right? Hello. And Deb Lindley again. Yep, I see you there, Deb. Thanks for stopping in. I hope you're feeling okay. Beth Prince, my very smart friend. I think the aspect ratio is off. You can fix it afterwards. I wonder how it got changed. What did I do? I'm so non-techie. I'm like, I probably pressed something. Is it very bizarre? Very bizarre. Yeah. Because even like this, you can't see what I'm doing, but the thing to the one side over here wouldn't have shown up. Looks like a shelf, actually. All right. Big Papa. 66 and 9 months. You're 66 and 9 months. You have to be 66 and 9 months to your full retirement age. Is I think what you're saying, right, Big Papa? If I work over SGA for 1 month, do I lose that month or the remaining 8 months? That depends. Are you filed? Are you receiving? I'm going to assume you're receiving. And then it will depend, are you in your trial work period? Or are you in your extended period of eligibility? Or are you after both of those? Because that'll make a huge difference. At one, the last one, you'd be ceased, cut off. If it's during your EPE, you'll just owe that 1 month back. If it's during your trial work period, nothing will happen. It'll just be considered a trial work period month until you have 9 of those in a rolling 5-year period. Kosher-ish, being friendly. I'd like to see that. Yeah, Deb, I love thrift stores too. I get everything there, except my intimate apparel. And no socks. And no shoes, actually. Richard Unknown. Hello, is it common for the SSA when they are requesting evidence from the VA not to include compensation exams? When I look at my denial, SSA didn't request. I suspect that might be true. I see that all the time. And so as a VA veteran that can get his own, you need to go do that, I think. Compensation exams, maybe look at something a little different than what SSA is going to be looking at, but they're still relevant. They're certainly not conclusive or anything like that. And SSA doesn't do ratings like VA does. So it's kind of like comparing workers' comp. But there's always going to be nuggets of opinions in there about limitations that aren't just filled with ratings and very proprietary type of metrics like ratings. That would be more universal. So for that reason, yeah, I always ask my clients to just make an order for them and get those. Kevin Johnson. Okay, this is alluding to his prior stuff, right, Kevin? Kevin's on reconsideration. It's been going on a really long time. You said 2 or 3 years, Kevin. It's one or the other. Two is long, though. and 3 is ungodly long. So I would be asking my attorney or my non-attorney rep, if you don't have one and you can get one, I would probably get one. You were denied already, and no one was rushing to award you on recon. Chances are you're gonna get another denial on recon. I hope if you've been, if you decided to go pro se, I hope you've been submitting all of your medical records updated. Maybe submit them every 3 months, except more quickly if you have something big that just happened, like you just had an operation or you had a diagnostic MRI that showed some really hefty things. It's the kind of thing you're going to want to get in front of them. So you got to kind of do the work on your case that your rep would be doing if you have one. And then because of the delay, unless the delay is good for you, which I wouldn't know without seeing your file, it could be good for you if you've been slacking on treatment. Not good for you otherwise, but if you've been slacking on treatment and you should have been doing things you didn't do, this delay is the time you should do it. So it depends what your situation is. If you've been doing everything and you are ready to be adjudicated because you've strengthened your case and yours is very, very tight, then I would contact my congressperson. You can go to their website and they all have a link. Sometimes it's hard to find. It's either through contact them or help with a federal agency, and you'll get their complaint question request for help form, and you can ask for it there. And they're going to make you sign something, probably with permission for them to reach out to the SSA on your behalf, and you're going to want to give it to them. Okay. I just did one yesterday morning or the morning before for one of my clients who's been sitting on initial for at least 6 months, 7 months without an adjudicator. If they were doing stuff, then that's fine. Okay, going back to Lisa. Lisa says that prior work, I think that's what WK means for you. Sometimes it means week, but in this case, I think she means work. 1993 to 2018, member of LLC. Nobody really cares about the structure. You're basically self-employed. Work from 93 to 2016. So maybe 2016 was your last credit earnings year? Is that the last time you paid taxes on money you pulled in? Look back, onset 2021, back 5 years, and all prior years gives me 5 working years. Well, if you're alleging an onset of 2021 and your DLI, I think you said was also 2021, they're going to go back 5 years from that, which brings you back to 2016. So that is going to be your past relevant work, if what I'm understanding your facts right. So your past relevant work, oh, I see. You said 2016 to 2012, but I think you meant 2016 to 2021. Well, that was just a typo. 20 credits over 10 years of onset, over 10 years before onset, correct? No. If you're saying I'm still insured, no. I'm not sure what your question is. Your 20 credits, the reason why you were still insured up to 2021 is because that's the last time you had 20 credits earned in the 10 years prior to 2021. The reason why you don't have it in 2022 is the 10 years prior to whichever quarter in 2022 you're looking at, you did not have 20 quarterly earnings credits, SSA credits, earned during those prior 20 years. Because remember, in 2022, 2011 was now scrolled off the board. So any work you did then is gone. And in 2022, which you added to that 10-year look back, you didn't have any because you didn't report any income to pay taxes on. Okay. So you have your work cut out for you, Lisa, just as a extra little comment here. Guys, when you have a remote DLI, date last insured, you have to prove your evidence that you have evidence from before your date last insured. So not today's, which is still important for a subsequent question if you ever get to it, but you might not get to it if you can't meet the first one. Is there enough evidence, sufficient evidence that the SSA is going to say, yes, we see she was disabled before her DLI of 2021. That evidence before 2021 shows that she was disabled. And then if they find that you were disabled, has it continued to the present? And that's what you gotta show. But the first question comes first. They're not going to go. It doesn't matter if you became disabled in 2022, 23, 24, 25, because you hadn't bought the insurance to cover any kind of disability in those years. You only covered any disability that started before your DLI in 2021. Okay, back to Richard. The exams concluded that I was 100% disabled and unemployable. It seems like that would play in my favor from those. I think they probably can't hurt. You're not only 100% disabled, which is a much easier threshold and doesn't mean that you're unable to work. The unemployable tends to add a little bit more to the theory that you can't work. I'm really going to start, I haven't done it yet. I keep meaning to dig further into the definition of unemployable under the VA and see what the differences are. If there are really no differences, then it all comes down to, does the SSA people who are tasked with determining disability, do they actually agree with the opinions of the people that found you unemployable at the VA? Not all adjudicators are going to agree. So, if one read in a report and maybe he was half asleep and he took it as gospel, whereas a different adjudicator, say over at the SSA, reads the same report and says, but wait a minute, this isn't consistent with what the guy said here. So this whole report is a little not so credible. And now that report doesn't have a lot of weight in the eyes of the SSA. That's just an example of what I would imagine could happen. So yeah, or the VA never had some of the stuff you had from SSA. They didn't have any of your SSA doctors' opinions and all that stuff. Or maybe subsequent things that came up, like improvements showing up in records subsequently. Like your VA records are from the past that got you VA disabled, but they don't show whether or not you improved, because they don't evaluate that later stuff, right? So if they, what if you had a surgery and now you're walking and talking and skydiving? Like the VA might not care, but SSA is going to care. So that is another thing I would imagine could come into play. And I'm giving kind of flamboyant examples. Sorry, I hear my tortoise rustling around. Kevin Johnson. Okay, great. You have an attorney. I wonder if he's reached out. Have you asked him? He's your attorney. You can ask him. Sometimes when I am not in such a rush to light a match under a case, because I know all that's been going on over the last few years, and I know that there are older cases, so mine isn't going to take precedence until those are wrapped up. So I don't do a congressional inquiry. But if my client says to me, this is really getting old, getting long, blah, blah, blah. If it's not unreasonable, really unreasonable to do it, I will, which is kind of like what happened this week. I said, all right, it's not unreasonable to do it, and even though the circumstances of the last couple of years make everything more drawn out, I'm going to go ahead and do it. Because we are getting some restructure and we do hear back. I mean, I did it and I heard back like the next day. So not from SSA, but from the congressperson. And it's this person's congressperson, not my congressperson. I have to use the one that's theirs, their constituent. Okay. Going back to Kevin real fast. Kevin, your attorney can see in the electronic file when the last time an SSA DDS person put something in the file. He's going to see if there was any HITMERs, and those are done by the SSA. So that wouldn't be like an external doctor finally sending his records, which they do that sometimes, and there's no adjudicator to look at it. So, you can kind of tell the difference. So, and he'll see that there might not be any requests from them, no copies of requests for medical evidence went out to any providers. And then you kind of know there's no adjudicator and it's sitting in the bullpen, or maybe on the bench and you got to get it in the bullpen. And that's what I think the congressional inquiry can do. You can get closer and pop them up where they should be. Art of practice is an excessive number of doctor's appointments, 2 to 3 weekly, only available during business hours, helpful for SSDI claim approval? If so, what's the best way to state that info during the reconsideration stage? First of all, the adjudicator is aware because they're the ones that have your medical records. So they see how often those things are. Maybe what you're saying is, I just want to kind of put it in, suggest that they think about it more, because maybe they don't maybe think along those lines. That could be, best way to set them is like, please note that, my doctor's appointments, which are, assuming they're super important, and that it's true that they're only available during business hours. Now notice, shift work is not during business hours necessarily. There's 2 shifts that are outside business hours. So could put a cog in that wheel. A lot of people work, 3 to 11 or 7 to 3 at night. So it's not going to eliminate all jobs, but it doesn't hurt to say, like, my treatment schedule is so heavy that I could not be holding down a job now. If any of those treatments that you have are with side effects, like if it's an actual treatment, like an infusion that leaves you completely demolished for 18 hours, that's something that's really important too. As long as it's not just your word and that it's kind of noted in the record, and maybe even expected through medical literature that these, side effects of these infusions are extreme fatigue for 18, that kind of thing. Doesn't sound like you have infusions, but who knows, right? And again, it's gonna, you said excessive number of doctor appointments. I think you mean excessive compared to normal people, right? But because of your conditions, you have to go a lot more. Assuming they are really like extremely needed, not just like, well, I like to go to my ortho every week and I got the money to do it. So I like, that might not really fly. Physical therapy though takes multiple times a week, oftentimes. However, those are usually available nights. I don't know about weekends, but evenings, I think. Well, who we got here? Gen X ants. Aw, Gen X ant. Are you Gen X? Are you the ant of a Gen X? That would put you up there because I think I'm a Gen X. Okay, I'm an older Gen X, I think. Sorry, I am late getting here. No problem, Gen X. I'm curious if submitting ADA responsible accommodations request from previous job is helpful. I had to have accommodations from 22 to 24 when I finally had to quit. There is a double-edged sword to that, Gen X, I believe. So I'm glad you asked that very good question. If it's during your past relevant work, PRW, those are those 5 years that we talk about. If your work was done accommodated, and if you could do that job with such accommodations, even if that job doesn't exist or the accommodations were taken away, if you could do that job with those accommodations, then that is part of your past relevant work that you have to prove you couldn't do even with the accommodations. If you didn't have those accommodations, and they don't really ask you about accommodations. I mean, they ask you about job duties on the work history report. So it's not clear to me that you would even have to talk about accommodations. So when we had accommodations and we could do the job with the accommodations, well, we did do the job with accommodations. Maybe we couldn't do it after they took them away. And I don't really like this. I don't think it's fair. This is a rule I would like to see changed. It's been around for a long time. If you could do that accommodated job now, or the SSA finds that you could, you lose under step 4. They don't even have to go and see if there are other jobs you can do because you can do your past job because it had accommodations. So you see what I'm saying? Like the fact that it had accommodations makes it much easier for them to find that you could do your past work, that job. So just be careful. It just makes it easier for them. It doesn't mean you can't still win. You can totally prove you'd have to prove that you'd probably have to prove that your condition, through medical evidence, not you saying so, has gotten worse since that time. The MRIs are worse, or the blood, whatever it is worse. Your complaints have been worse for a couple, since 24 or earlier. If you already told them about it, your worsened conditions could be evidence that you couldn't even do that accommodated job. But what if your condition has just always been bad and you did the accommodated job, but it doesn't exist anymore? You're still going to be held as if it's a process of work. So it's a real difficult thing if you had accommodated work. That is very different from whether you could only do a job now accommodated. So like, let's say the separate question is, could she do a different job? And someone says, well, she could do a different job if it was accommodated, so she should lose. That doesn't apply. Any other work existing in substantial numbers in the economy is in a competitive work environment and excludes accommodated work. But it doesn't apply to that review for that one purpose of past relevant work. Crazy, huh? Okay, we have Angela here. Angela, you have no name in your box. I wonder why. Lawyer says my benefits won't be affected from my recent settlement lawsuit I will be getting. What can I tell him to make sure any income-based programs are not affected? You can tell him whatever you want. He doesn't control whether you have income-based programs. You need an income-based program lawyer for that. Why don't you'll have to go get a consult with, if you're getting welfare from something, that can be affected for sure with other income. If you had SSI, that recent settlement would affect. But your lawyer is right when he says your SSDI is not going to be affected by monies from a lawsuit, because that's not work activity income that you did during the period you say you're unable to work. He cannot change the SSD structure to accommodate probably what's hundreds or thousands of welfare programs throughout the state and every little grant program and all that. It's all welfare programs. He has nothing to do with that. you filed for SSD because you wanted your Social Security disability insurance. Of course, if you have more income, it's going to eliminate potentially some welfare needs-based stuff that is no longer needed because you now have the income to self-support yourself for what you're getting from them. That's the way that rolls. He's not going to be the one to, in all likelihood, he's not going to be the one to be a knight in shining armor, because he can't. He simply can't, no more than your mother could, or, you know, anything else. You need something else. I mean, you could go, if that particular welfare program that you're relying on is, let's say it is the kind where if you have all your monies in a specific kind of trust, they don't count for that program. SSI has something like that. Then you could talk to somebody about getting those back benefits, maybe put into that trust where you're not going to have control and be able to spend them, but at least, you know, you're getting what you're asking about, but you'll still have that income unless there's, you know, trust way of siphoning it away from you. But that might be contrary to the purposes of, you know, needs-based programs, because it's supposed to be for those that don't have that extra income coming in. All right. Lisa Gilbert, onset date March 2021. On the initial online application, do I list the LLC from 1993 to 2018 as my second prior job or as my only prior job? Well, it's going to ask, it's going to be everything. I think they say all your jobs going back from today. So if you have anything going back, and then it says probably going back to, I forget how it's worded, 5 years prior to the date you allege. If you're DLI, and they give you something simpler. I would, like, we're talking about all these nuances of what's going to actually count in the long run. They're not asking you to figure that out here. They just want you to put in what they asked for. So go back and put in every job. When they see the dates, then they do the various maths. And they ask, I think, from the present back, because if you have little work going on now, they want to know about it. The existence of an LLC is not the same as working it. If you are working it and making money off it, you're going to have to explain that. But yeah, even though that's the last where credits earned, they want to know if you're working under the table too. So credits don't answer all the questions about work. A lot of people work and they don't earn enough to make credits, but they're upfront about their work, and they maybe did tax returns and paid a little bit of taxes, but it was never enough for credits in any given year. That still has to be looked at, because what kind of work was that? Like, let's say you had a bad back, but you were baling hay at a farm, making, you know, under, not enough to get credits, and certainly under SGA, but doing that kind of work is also evidence of not having such a bad back that you've alleged. So when they don't try to limit your answers to what you think they're going to need. There's a whole plethora of reasons why they want to just give us the work going back. Okay. Angela, again, I have only applied for disability. I have not yet gotten approved. I did have the mental evaluation though. Well, I hope it went well. I don't see a question there, but that's good. You might have a response soon, Angela, by the way, from the adjudicator. In a perfect world, in a normal world, before maybe a few years ago, and still often now, you get an answer pretty quickly after your CEs. Adam, you're welcome, Adam. Nice to see you again. Oh, hey. Yeah, 77% is high. I'll take that in all of my cases. He's referring to the statistics someone above had noted about their judge's rating that they found online, win rate, and that is high. I'd like all my judges to have such a rate, but it ain't happening. You need to just do the packets, and we will look at them later. We don't spend time doing piecemeal, okay? We got a lot of work to do. So get your work done, and then we'll be looking at it all. All right? That's how it gets done. So do the best job you can, follow the directions, consider the space limitations, hint, hint, and we will be wading through it, and we will be figuring it out. So you don't have to worry about that, okay? All right. Tiger Bite. My VA award letter states my condition for my award. My VA award letter states my condition for my award, which coincide with the listings for PTSD. Well, a condition alone does not coincide with a listing. It just might be the same diagnosis as a listing is under, but then the listing says, and it's got to be so severe as to have all this. Clearly, in all the medical records, old, new, the whole time. I know they are different entities, but does my award letter hold weight for SSDI? It's evidence. It's evidence. It's just not conclusive evidence. The VA letter shows the opinion of someone at the VA that you met a definition that is not the same as the SSD definition. So obviously there's limitations there. You know, it certainly confirms that you meet whichever step about MDI. Oh, she's got medically determinable impairments. Yes, because the evidence that supported the VA thing is going to be the evidence that's also in front of the SSA. They get all those medical records, right? You want them to. And really, depending on how good those medical records are, VA is much different and easier in a lot of ways to prevail on because they have a much more lenient definition of disabled. You don't have to be unable to work to get a VA disability. I mean, that's like apples and oranges, right? All right, rat's nest. Is it detrimental if you report you get along well with authority, past bosses, and such on function report? Couldn't find a video on that question. Not sure how to answer. Good question. I would say no, unless you are claiming that you have anger management and impulsivity problems and you react poorly when told what to do. I mean, so if you just have physical, no, my gosh, most of my people all get along reportedly fine. None have been canned by a boss or in any other job. And that's true with mental health cases too, because not all mental health cases, cases that need a little mental health issue to get the person over the hump don't have to be like uncontrolled people who can't, control their behavior, impulsivity and hallucinations and psychosis and anger management, really some bad stuff. By no means. If one was saying, that is my problem, I don't have physical issues, that is my problem, and I can't work because of it. I mean, you can't be saying I can't work because of it because I'll lash out at my boss and then say on your report that you have no problem. Authority figure, I would assume to be a boss too. You know what I mean? It's not just police officers or, So maybe there should be a video on that, rat's nest, because if you're asking it, it's probably a question other people have too. So thank you for bringing it up. But definitely not an issue at all, unless it is, right? So don't feel like you have to say it is, or you're hurting yourself, by being frank. Deb Lindley, yep, I'm glad you're feeling a little better. Okay, let's see. Umo says, as a P&T veteran, your SSDI claim will be expedited more than likely. It's supposed to be. It's supposed to be one of those. There is a ton of them, obviously, that are expedited. That's just one category that is. So how expedited it is, I can't really say. I have a feeling a terminally ill person probably takes precedence over that, but they are definitely amongst the categories of expedited or put to the front, however you want to put it. Big Papa, you are so welcome. Broke Dance Mom, thank you so much. I appreciate that. Me Heidi. Hey, me Heidi. Good to see you again. What happens if my SSA lawyer dies? I always wonder about that because I'm like, I'm getting up there in years. And you just never know. You can get run over by a truck. He was independent and didn't even have admin. We are at the tip of initial. Said we would have our initial determination by May 9th. SSA said, what do they know? Maybe you will, maybe you won't. Well, I don't know what arrangements he has. Most of us have colleagues that we talk to because we're all human, and we have colleagues that we would have take our cases should we become unable for whatever reason or another. That's if your lawyer did pass, of course you'd get a different one, right? Let's hope that doesn't happen. But yeah, I mean, even with staff, you still have to have someone you're going to give your cases to because, your staff is not necessarily capable of becoming representatives themselves and handling the whole umbrella of things that have to be done, right? Angela, okay. Extra info, I'm currently working full-time at a nursing home as an activities assistant because I desperately need income. No lawyer either. Well, if you told the SSA, Angela, that you're working full-time, did you say, you already filed and you haven't reported it to the SSA? That's a no-no. You have to, because the first question in the sequential evaluation process, which you either weren't working at the time, so it was answered properly, or it wasn't, is the person working SGA? SGA is over $1,620 a month gross and or full-time. Right now, you're telling us, if I were you, I would withdraw my claim. I would tell them that I'm working full-time, withdraw the claim. You don't want to be caught for fraud. right? So withdraw the claim, explain, I picked up this job full-time, I'm trying it. It would, and let me just tell you, if it doesn't last 6 months, you can argue that it was a failed work attempt. But while you're working it, they cannot award you. You fail at step 1. Okay. I commend you for trying to work full time, and so far you're doing okay. I don't know how long you've been doing it, but you have to be upfront with them about it, or it's going to look very bad. You're not telling them something that is critical to your case. Step 1 is the person working SGA. So I would get on that, and then you have to refile. If you drop down to part-time and make less than $1,620 a month gross, and don't flirt with it too much, because an extra shift is going to put you over and it screws up your whole shift. If you can drop it down and get by, do that. And then you don't have to worry about this. You're not doing anything. You're not failing to do something you are legally obligated to report to them. I mean, you're legally obligated to report you're working, but it's not going to be, I'm working full time while I'm claiming I can't even work. SGA. It's a real bad optic, and it could be dangerous. I don't think it will be for you, because you clearly didn't know. You're not doing this intentionally, but you have to tell them. You just have to tell them. Either that or curb it back today. Say to your boss, I can only do X hours. Obviously, the higher the dollar hour you're making, I know everyone wants to make the most they can, the less hours you are allowed to work. And sometimes that doesn't work too well with employers who want, like, I want 25 hours a week, but that 25 hours a week puts you over SGA. Lower income hourly rate workers don't have that problem. They can do the 25, at least from a financial point of view. Optically, it's all not so great. Activities assistant, I don't know how, that sounds like it's at least light level work. If you are under 55, that itself might put a fork in your case from the way they do things later. I'm just seeing all the things down the road. But yeah, you got some stuff to do there. Okay. Angela also says, so I'm asking if I will not be eligible because working full time. Yeah, as I just said, not a regular job though, not unusual waitressing income, not usual waitressing income, etc. Doesn't matter. No, that's a job. That's like a preschool teacher, right? And some of them are like children, when they're in nursing homes, in terms of mentality and physical abilities, right? Yeah. I'm less concerned about you getting denied than I am about you getting a kind of a black mark for working full time and not telling the SSA. I'm more worried about that, because it can be seen as fraud against the government. You don't want that. Lisa Gilbert, I have enough evidence prior to 2021 and more after. Well, you have to have enough prior, so that's excellent, Lisa. And more after, that's excellent too. Disabled in March 2021. Wow, you only have that. So all the evidence, Lisa, doesn't mean you can't show stuff from before March 2021, but they have to find enough that was born between 2021 and December of 2021. March and December of 2021. You got a short window there. Yeesh, 9 months. That's unfortunate. Maybe you got it. When they look at this stuff from before March, and if it was and you were complaining to your doctors and it was horrible, everything was going so bad, but it's a tough one. Kevin Johnson, I have an attorney. I'm the one that needs left. Thanks for reiterating this, Kevin, because I'm going to forget all the details. That needs left knee surgery, strong MRI, have 5 to 6 steroid shots in knee. They failed orthopedic doctor recommended surgery. It's all on file and got Marsha Blackburn. Marsha Blackburn? Oh my gosh. What do you mean? Specify. What does that mean? I forget what your original question was. By the way, one left knee bad probably isn't going to be disabling for most people, but it could be if you're up in the grids, I suppose. Okay. Your attorney knows what to do. I have no worries. Miss Frantic, I remember last week she won her case. Since my OTR last week, I haven't been able to get my attorney to answer my calls or emails. Don't even bother emailing him. I requested he that forward me the cancellation of hearing an OTR email to me. Well, first of all, he probably didn't get the letter. They don't send it out necessarily the same day. It just happened. Yeah, don't even worry. You don't need it. You'll get it yourself. And it probably won't be a cancel. I'm not even sure they send cancellation letters. They send decisions. Just be patient, Miss Frantic. Don't be so frantic. Do you know, if she goes further, do you know if there's some legal reason in Illinois he wouldn't be allowed to send it to me? Of course not. There's no reason whatsoever. I just don't know that he has it. Or, it could be he's busy. He worked his butt off and got you the best result possible, potentially. So let him work with his other clients. You're kind of sitting on easy street. Let him use his hours now for the people that need to get up there too. Don't win it and then try to hoard them. And I know that's not what you're trying to do, but you know, this is how he keeps the wheels going for everybody. He can't be like, oh, not that sending the letter takes a lot of time, but I'm guessing he doesn't have it yet. You know, our mail, once they send something, it takes like 10 days to get here, sometimes more, 2 weeks. And then you got to get through the mail. And then you have to address the ones that are priority, not the ones that Miss Frantic has, because it's all good news and she already knows about the good news. Do you know what I mean? Priorities. That's all. Priorities. I don't know that hearing dates show up in your account. I don't know that they do. You guys can tell me. Once you have one, does it show up on your online account? I say that because I know that it shows up in the other because it comes out in a letter. But it doesn't mean things that come out in letters don't necessarily come out in your online account. And yeah, so you guys maybe could tell me better. When you get a hearing date, does it show up in your online account? Does it say you have an OHO hearing with ALJ so-and-so? I don't think it's going to even say the name of the person because that can change, you know. But, you know, you tell me. I don't have access to what you see in your account. All right, Daryl Smith. I have IBS and I have to wear depends, and use a walker because of dizziness. Have had several TBI and TIAs. I'm so sorry, Daryl. I have several cognitive problems. I submitted my SSDI application in November last year. Have not heard. Are you self-representing, Daryl? If so, is that wise, considering you have several cognitive problems? I mean, what's the chance you're going to do a good job for yourself? Just saying. So the fact that you did not hear, and it's been since November, that's quite some time, that suggests to me that maybe you didn't submit it properly. Maybe you missed a step. Could be. That's what will happen. If it never gets there, there is nothing for them to respond to because you don't even have an active claim. I really think you should, you know, get a representative. The mere optics, let's say you were doing it well, that kind of belies cognitive problems from the TBI and the TIA, plural. And that might just mean you have to rely on your physical problems, which sound pretty significant, by the way, if the records are really, really extraordinarily strong with regard to dizziness, which is often considered subjective. So you'd have to have really strong, good evidence. Okay. Should be. Okay. Nice to see you again. Just got out of FQR. Sounds like Shub, I know we talked last week. Refresh me. He had that auditing, it sounds like, where he's one of the lucky ones, quote unquote, unlucky ones to get pulled for audit after a determination was made. I guess they want to see if all the steps were followed by the adjudicator. And now he's saying it finished that and it's going to non-medical requirements. That should be the last second. Ironically, normally I'd say if they're going to non-medical review, it's because the medical prevailed in your favor, because you don't need non-medical review if the medical failed. But because there has been that mixed messaging for almost 2 years now, where they tell people they're in non-medical requirements and therefore they think they prevailed on their medical, because why would it go to, you know, non-medical? I can't even say. So Shub is 56. He was a CDL driver for 30 years, osteoarthritis both knees. Am I getting close? I think you're getting very close. And I bet you have a great case. And fingers crossed, I think it sounds like it would be going in your favor. Daryl Smith. I submitted my SSD application in November last year and have not heard anything. Okay, so you have a lawyer. Well, then call your lawyer. Or if he has a portal, which I hope he does, you just message him through there. And then, you know, if you have a lawyer, my goodness, yeah, then that should be different, right? You still should have gotten letters, though. Like a letter saying, we got your application. That's the letter I'm talking about. And there should probably be a letter that says, we got your appointment of representation, appointing so-and-so lawyer as your representative. Now, I will say, I have cases from November who we haven't gotten that yet. And the word from the SSA when I call is that, yeah, it's in the queue to be processed. So we'll see. We nag them and eventually it gets done. But it is a slow road, you know. Always. Some of them fly through and then some of them are, you know, sitting there. Okay, we did Shub. Shub or Shub? Okay. Kelly McPherson. Hi, Kelly. I'm 58. I was awarded SSDI 1 year ago. No medical diary, but in things to remember, it's said in 5 to 7 years they will review me. That is your medical diary. 5 to 7 years. So does that mean CDR? Yes. Yep. That's what that should mean. So that's very good. They don't expect you to improve. So just keep up with your basics treatment-wise. So you always have that rear view window with the evidence once they do CDR you. It could very well be also that when your time for CDR comes, they take a look at the world around them and they say, I don't think she's improved given what she had. And we see no major medical technological breakthroughs that she could have had, even like that they just don't exist to have been something that would improve her enough to prevail, to go back to some sort of basic work. So it's probably very helpful for you, Kelly. But I always say it's easy enough to get follow-up treatment, which is what you're probably doing anyway. So just continue to do it, in a reasonable manner for a person. It doesn't have to be as robustful as when you were applying, because you are a 5 to 7 year medical improvement not expected. If they gave you a 2-year, I'd be like, you have to continue going balls to the wall. If you're a young person or they give you a short CDR, I think the shorter it is, the more robust your ongoing stuff best be. So you cannot, it'll be clear that you haven't improved. G. Ray. Hi, G. I'm so thrilled to catch you live. Haven't you called me here before? I thought you did. And thank you in person. Oh, you're so welcome. Thank you for being here. I went back to work only 4 hours a week from an ER nurse of 43 years to a concierge. It is a low stress, easy job. It's been great mentally. Yeah, we did speak about this, right? Yeah, because it's very short hours. That's why I think that we did speak. I think that's going to be wonderfully fine. Deb Lindley. Oh, she's talking to Ms. Frantic. Gen X. Okay, you're welcome, Gen X. Maeve. Hi, Maeve. I know we are playing a little tag, right? I once asked for accommodation back in 2005, and they promptly put me in one of their layoffs. Okay. I knew my boss was mad. I also knew that it was not likely to help much because I still missed work. But you got laid off, right? I'm not sure what that means. Hopefully you're around later, Maeve, and I'm going to give you a buzz. Today's my day. Deanna Rogers. Is it Dina or Deanna? It's a lovely name. Second mental evaluation this month. Would you be very evasive while answering? It's telehealth. I would not be willfully evasive, no. Why would you be evasive? It'll be looking like you're hiding something, potentially. So if you're naturally not evasive, I don't know, you want them to know what's going on. I don't know the facts of your case, so I can't speak specifically, but I don't know why one would be evasive. Hi, Angela. Yeah, I mean, you'd have to, if you're collecting some sort of welfare, then you need to find out if that welfare program will not count monies that are in a particular trust, and if so, what kind of trust? If it's a special needs trust, note that you will be the beneficiary, but not in control of it, and someone else will control it and only give it out for certain purposes. Just know that, that's the crux of it. If that's what you're trying to do. G. Burnett. I know that SSDI can be deducted from my LTD payment, okay, by LTD, yeah. But if I file for Social Security at 62 years, can they deduct that also? You're going to have to look at your LTD policy. I wouldn't be surprised if it goes on forever, but that's an LTD issue and not a Social Security issue. That's their role. Okay. Hi, Taylor. Taylor says he keeps reading different things about CDRs. Most people say after 55, it automatically goes to 5 to 7 years. It's confusing. Well, I suggest you look for the law then. If they're saying it and they don't produce the law, and there's laws, anything that's a rule is going to be in a law or a reg. If they don't produce it, I would be very suspicious. The biggest lies come from unsubstantiated statements, okay? And also know that what they might be saying to you is they believe that 55-year-olds most likely escape CDRs. That might be true too. Not because of a rule that says they can't give it to 55-year-olds, but because they might be passed upon because of the nature of their specific impairment, the way that the grids change at 55 from 54. So to be found improved enough to go back to work would require a whole different analysis that's harder for the SSA and easier for the claimant to prevail on. But that's not the same question as what you're saying. What you keep saying you're reading is, I've been told. Well, then ask those people, show me the rule. I mean, if one person says, I bet you this happens, and then they tell it to another, and then they tell it to another, and now all of a sudden it's this echo chamber of this thing that isn't even true, This is what you get. And by the way, this is exactly what the media does. Not that I've heard them do it with this, but one reporter will say this, and another reporter will say, it is reported that. And then now you know every source is saying the same thing based on an anonymous source originally that's probably been fabricated by the reporter and is not even actually in a source that's anonymous. He kept it anonymous, whatever. I mean, it's just ridiculous. Get the rule, get the law, and then people can look at it. That's all, right? If they can't produce it, then they don't actually know it and they're just guessing. And they might be guessing for a reason. Maybe they want to see everybody that would, the portion of 55 plusers that are going to get CDR'd, maybe they want them to screw up. Maybe that person is like, wow, the funds will be stronger if all these people get booted because I convinced them that they don't have to take care of their case. I just wouldn't slack that way. Angela says, and Angela, I love this actually. I think you're brilliant, or certainly intuitive, because I actually have a video on people should be with social media when they have a claim. She says, I have no name on my picture because I was completely laying off social media during lawsuit. Excellent. And you may as well stay that way while you're, pursuing Social Security disability. But that's irrespective of what I told you about the rule about reporting and all that stuff with SGA at step 1. But guys, what Angela's saying here is smart for everybody. A lot of people here do have screen names. Some people use their real names. And depending on what's going on with them, that's fine. But social media, it can be a really bad thing because we put up things that look like they happened yesterday and they happened 5 years ago. And they're very active and all this stuff. It's being seen. Or they're on all the time, jabbering publicly. And this is when they say they're very reclusive, which could be physically, and don't like people and can't really spell very well. You know what I mean? And there you are, like keyboard warrior. You just got to be careful because the time on can also be time you can be sitting at a desk, even though you might be in your recliner on your iPad, doing it. It's the overall appearance that matters. Nobody's going to know the details that could save that impression from being, right? So be careful, please. R&D wants to know, and I'm not going to know the answer. We could look it up. Is genitourinary prolapse in the SSDI Blue Book? I think he means as a listing. RJ, probably not, is my guess. However, that doesn't mean it's not disabling, and most people don't win on a listing. So do it the old-fashioned way, Urinary frequency, chronic bladder and pelvic pain. I had mesh complication surgeries. I'm so sorry about that. That's horrible. So even if it's not in the listing, and if it is, it's got to be the details in the listing that you have to meet about the severity and everything. If you meet them anyway, and it's not a listing, you're going to win under the typical RFC way of doing it, right? Okay, let's see. Rift 920. I'm going to call you Rift. RFT. My sister, thank you for being here, by the way. My sister was denied for SSI when she had cancer. She died a few months later. I am so sorry. The rules are not fair for some people. Was she denied based on them finding her not disabled? Was she denied, because you said SSI, based on her lack of sufficiently low funds? Was her doctors not noting it was terminal? If it was terminal, she wouldn't have been denied. If it was terminal in the records. Now, she might have died and they didn't have her as terminal. I know someone who died of something different than cancer, but it was like adrenal failure, chronic, with a bunch of other things, but person did end up dying unexpectedly from the condition, but they were never deemed terminal either. And so we didn't win on that basis. We did win after he passed away. And so his wife and child were able to get those benefits, which was good. But yeah, that wouldn't be an unfair rule. What's unfair is that the person got the cancer to begin with, is what I would say. And unfair that the doctor may have not recognized that it was terminal, right? I mean, it's not the Social Security rule right there that's unfair. It's the other things in life that are going on that, brought it to that. And a lot more costly. I mean, Social Security, SSI, her life, her life is gone, right, because of the cancer. Riff says, do you always have to go in front of a judge when you file for SSDI? No. In fact, you can opt out. You will see when you file your appeal for an ALJ hearing, it asks you if you want to go, if you want to have a hearing with the judge or have it just go on your paper evidence. We always say we want to go in front of a judge. So, but you don't have to, it would really depend on, I suppose, why you're doing that. If you're shy, I mean, remember, there are MS Team hearings now. You can also do a phone hearing for MS Teams, but if you don't, want to be seen, maybe, I don't know, whatever the reason is, but no, you don't have to go in front of a judge. The judge will make the decision if you're up to a judge's appealed for ALJ rendering a decision, but you don't have to have a hearing if you don't want to. Najanalj? Am I saying that right? If a person received benefits as a disabled child, does that help years later if they've applied for SSDI after years of working and managing disabilities with accommodations? I would think so. It doesn't hurt. If it's the same disability, and as we age, it might, the person was able to work with accommodations, but then as we age, sometimes those disabling conditions are, degenerative. We get not just the stuff that we were born with or as a child, but we start getting the age degeneration that everyone goes through on top of what we already suffered from. So all that can affect, sure. And the fact that the disabling aspect was that long ago, it's just going to tell a historical perspective. So it can be helpful. It's not going to be determinative, of course, because as you said, he's already proven that he was SSDI able, or she, and therefore there's no DAC, right? If it was SGA. So let's see, Lisa Gilbert again. Hi, Lisa. To clarify, if my onset is March 2021 and DLI was December 31st, yes, you got a very small window, as we said. That wasn't unclear. And my work history credits are from 2016 backwards. Yes, that's where your DLI, you already know your DLI, so it doesn't really matter what your work history credits are. You already know your DLI. We use those to figure out the DLI. That means I have 5 years worked. 2012, yes, or 20, looks like it could be 2011. It's going to be 5 years from whatever. I have 5 years work from 2012 to 2016 out of past 10. The past 10 doesn't even matter right now. You already know your DLI. It's 2021. That's where you stem it back from. So I don't even know what question you're asking. Is it true? Is what true? Your DLI is the date they're going to stem it from. And it goes, assuming this is SSD, by the way, and it'll go backwards from that DLI. That's going to be your past relevant work. The rest of it doesn't matter. It's already been determined. That was determined early on. We need to know our DLI so we know what, and so which jobs we can look at. Okay, does that make sense? Yeah. Okay, so I hope that clarifies, Lisa. Angela. So even if I only applied and had zero income at the time, that's good. You hadn't started work yet, right, Angela? I have to tell them yes, of course. Yeah, you're working full time. You have to tell them even if you go back to work part-time. And that was in your documentation. If you did it online, it came out there. And if you didn't read it or print it or whatever, that's kind of on you. What if it lasts more than 6 months and if it lasts more than 6 months, it is a successful work attempt and you are no longer disabled, even if you were. So I always tell people to look carefully at that. If you are dying on the job, like it is so hard, it's not going to last longer, and you keep pulling it out, maybe calling extra sick days, just to not totally get fired, that might not be the best thing to do because you are going to defeat that claim. Now, if you stop again, you can reapply, but you can't go back. You can't go back and pick that earlier date again as your onset. Now you have to do at least the day after the day you last worked, the new date. Sometimes I say, if you're about to poop it out anyway, meaning get out of the job, maybe do it the week before 6 months instead of the week after, because it's night and day, by and large. Okay. Yeah. So you're she said she cannot ask for less hours because I'm a new employee. Well, choices. We have choices. If it's working out well for you though, and you can do it, and you're not dying, then great. You've got a full-time job you can do, right? So those are questions you have to answer for yourself, really. Oh, Maeve, I've already submitted my work history, but I've since done a mystery shopper job. These are piece work, not taxed. Why aren't they taxed? Are you sure about that? But reported of more than X in year and run 3 to 22 per job. If you're saying they're not taxed, that's because it's a 1099, right? It's still relevant for SSA stuff. And I would be, if we speak, Maeve, like if you were my client, I would be looking at your work history report that you submitted and I might be redoing it with you, depending on what you may have said. I rarely ever saw a perfectly done work history report that didn't have damaging stuff that was not accurate. And now with the new version, even more so, not a single one. So it's really important to know what each question is and to know what people leave out so many things in their job that would actually help their case. And that's what we try to get on paper. All right. But anyway, I hope I talk to you later. I think you're the Maeve, right? The Maeve. And she's clarifying here, guys. If I'm lucky, I can pull $30 in a month. So like one job a month, right? It's not going to defeat your case if that's all you're working. The work is entirely at my leisure. Should I send an update fax? I think that would depend if and when you started. I don't know how urgent it is at this juncture. You are presumably, well, you might not get a 1099 because it's going to be potentially less than $600 for the whole year. But you do have a duty to report all work activity to SSA. Now we know they're going to find that to be not SGA. And it's also, because it's not even going to be, it's probably going to be for monetary reasons alone, but also the activity itself is probably not one that has much marketable value, generally speaking. So it's not going to harm you to report it. That's why I always say, why would you not report something? I mean, you have to report everything legally that you have to report, but don't even be worried about the stuff that's not going to hurt you anyway, right? Wear it on your forehead. Rumham. Do you think it's better if I fill out the paperwork or my lawyer? I feel like his answers might be shorter, but is that better? I can't believe you're even asking this question. Who do you think knows how to write it better, you or your lawyer? My guess is your lawyer. And he's doing it based on your information, right? Presumably you gave him the information and he's wording it properly and making sure that you're responsive and that none of the things you say are twistable and that you're not also putting in a bunch of filler that is irrelevant and going to detract the reader from the pertinent things that could help your case. You don't want it to get lost in a blizzard or in the weeds. A lot of people put things in that are not relevant. They don't realize it's not relevant because it's near and dear to their heart or their feelings. And, it can have a reverse effect. Let's put it that way. And, or it can almost optically be inconsistent with something else they said. And now they just made themselves, they just cause a weakening of their case with their function report. I'm assuming you're talking about the function report. But yeah, why would you have a lawyer if you think you're going to do a better job than him? Seriously, like why pay him? Right? I wouldn't. If I thought I could do a better job than my lawyer, I'd do it myself. Deanna, I forget what your original question was. Let me just scroll up to Deanna. Damn, that was way up here. There she is. Be very evasive while answering. Well, so I'm going back down. That was a question. Should she be evasive on a mental health exam? And I don't think she should ever be evasive. I still have Rumham up there. I have and take care of my infant son with CP. Lots of family support. Yeah, that's very intensely busy work, right? As a parent with a special needs child, right? Medically needy. If you discuss it, if they ask if you have kids, you have to say, are you a stay-at-home mom? Be like, well, I am home with my son, but you're saying you have, obviously if you're claiming disability, you're saying you have severe medical impairments that prevent full-time work anyway, because it can't be I'm staying home because I want to take care of my son. That's not disability. But you can also emphasize the lots of family support. Is someone there with you a lot during the day with your son? Does someone take over so you can go nap? I don't know what your medical impairments are, so what your needs are in terms of, if you're being able to take care of our regular children is not indicative of not being disabled, right? Specifically. Or generally, of course, things we might do that we then explain how we do this and this with our kid. I've seen people do that where they describe how wonderful of a parent they are because they're running around, going to ball games 7 times a week and sitting through 12-hour day wrestling matches, tournaments. Did this over the winter. It's kind of grueling. Your butt really hurts on those bleachers. And their point is they want to show that they're such a good person, a good parent, and it's so sad that I have these disabilities. And it's like, really? Sadness doesn't get you disability. And you just described a person that has less disabling functional aspects than what you kind of suggested in your application. It doesn't sound like you couldn't do a sedentary or light job because you're engaging in a light lifestyle, seemingly full-time, right? So you got to look at it from the perspective of what does this reflect about what I could do on a job. Yeah, Angela, you're 45. You will inform them about current work. I will be able to pick up later in life with where I left off. Example, I guess I'm asking if my records will still be relevant. When you file again later or continue, the current records are the most important, or the ones that occurred within your deal. Old ones, not so much, but we use them when they show that a problem started here and now look how bad it is, SSA. And that's why she might not have been disabled here because she worked full-time as an activities director, but 3 years later here, she had to come back and look at the MRI show all this worsening. And that I think can help show that really is the date, because that person was trying to work. Here you are trying to work full-time and collect. That's a mistake. And I know you just didn't realize the rules on that. But the historical medical records from before you were disabled, such as the ones thus far, well, it might not be if this becomes an unsuccessful work attempt, right? So it depends on what you choose to do with that job. It sounds like you're going to keep going, and I think that's great. I would withdraw. I would report it, and if you hit 6 months, I would withdraw the claim, so that they don't keep spending taxpayer money working it up when you have secretly, continued working. They will eventually deny you, and then you're not going to appeal it unless you like to really waste time, So that 6 month mark is really the big thing for you. You have an uphill battle at 45. Plus, you just showed that you could work full time for at least a basis, if not a sustained basis. So you're in the worst age bracket. We do win those all the time. However, those are really, really extreme. And those are disabled people that can't move about. They could never go out and do it full time, even for a week. So there is a difference. So, right now you probably have a difficult time establishing that you're different from most people with your condition because you're able to work. So your medical records probably, I'm guessing, don't really get you there yet. You have impairments or else you wouldn't be doing it. So, and I hope they don't get worse, but things tend to, and we get older and all that, but it is an uphill battle, but hang in there and just protect your own safety by reporting that to them. Hi, James. Good to see you. If SSA determines that I am still disabled at the reconsideration stage, can I have a lawyer get a copy of my e-folder? I want to know if you have a lawyer, your lawyer can get a copy of the e-folder. He has access to it the entire time once he gets connected to your file. If you don't have a lawyer, then he can't. Can you get a lawyer to do it? No, he has to be your representative to have easy access like that. Or you would just be ordering your record with a 3288 form anyway. So it really depends on what you're doing in terms of retaining a lawyer as an appointed representative or not. But you have a right to request your file from the SSA at any time. You're at the reconsideration stage. You can ask for it now if you can get through to the SSA and just say, can you email me a copy of my SSA folder? I'm at reconsideration. I need to know what's in there so I can get what's missing. You can call the adjudicator and they could tell you what they got that was on your list when you filed for appeal and from your application, and if anything was missing. That's something to do because you want to make sure you get those missing records in there. I mean, the burden is on you in the end, particularly if you don't have a lawyer. Okay. So, yeah, Ms. Frantic is saying that her lawyer had got an email that day, probably from the judge's assistant, saying that the hearing was canceled. It's probably his assistant that goes to the emails or whatever. Just tell him to shoot you a copy maybe. Whatever it is, but I wouldn't be doubting that it was canceled if you're worried about it. Don't be frantic, Miss Frantic. But they're probably just trying to get all the work done that they didn't do the week before because they were finishing up that brief for you. And now, we got to let them do their work. This is kind of a nothing burger, truly. If you don't trust it, give the OHO a call. Your case is over. You could say, hey, I just want to confirm that my hearing was canceled because I got an OTR. Can you let me know? And speak to the receptionist who may or may not be able to answer, but they can give you the judge's assistant. You can leave a message there. But, have a little faith in your lawyer. Okay. Kevin Johnson. Oh, I don't know what that is. Oh, he's just talking to someone else, I think. Okay. It's okay, Angela. Sorry, ongoing questions I have. So you're saying I cannot inform them. No, I said you have to inform them. If and when I get an acceptance notification letter, that would be fraud. It says in your directions that if you start working, you have to tell them. I'm just reiterating what they tell you. I have seen, and now this is a whole other thing. I had a case once where my client didn't tell me, I think we were on recon, that he had, I forget if it wasn't that he didn't tell me, he went back to, he either had stopped working and then he went back and it was over SGA and it had been like 4 months and he prevailed and they didn't know and I didn't know. So I find out and we just gotten this prevail. It all happened to it. And I said, he'd been working for like 4 months. And I said, you better stop working right now. You won. But they're going to go back and they're going to count all the TWP months. Trial work period is all going to be implicated now, which is fine. And he didn't get in trouble, I will say, as far as I know, for not reporting it. You know, they're not trying to look to accuse people of fraud because they know this mistake happens all the time, Angela. So I don't want to make you paranoid, but I am telling you what your duty is. If you wait, I just don't want to say never could it be a problem because, you know, it is an intentional withholding at this point. It is. I was concerned when it happened with him, not because I'd had experience where someone got in trouble, because my people generally communicate with me better than he did. And so he didn't stop. It was killing him, by the way. I mean, that's the kind of guy he was. And he was starving, so he kind of had to. He was single. He had some cats he had to feed. I'm not kidding. But, you know, it was worrisome. And he went like I said, it was like 4 months. And then he did stop because now he had won too. And he didn't need the money as much, thank goodness. And I know that's your problem too, Angela. I totally get the dilemma. But I'm going to just say, just know your risks, okay? And it's not unforeseeable that if they find out, they award you, and then they find out you worked 7 months or 8 months, and if they paid you, now you haven't, they could reverse the whole thing. They will have to probably. It'll be a bad decision based on their misinformation from you. And then those back benefits they send you, and you're saying, well, I'll tell them probably when I get the notification that I got awarded, and they might have to reopen it and then unaward you. So I just think you're kind of doing an injustice to the system also, because if you're having them spend time that they shouldn't be spending, you know, if you're on 5 month, if you're planning on working over it, it doesn't matter. I mean, you're going to lose all that anyway. So why have them keep going? If you're like, I'm feeling good and I'm going to keep going past 6 months, you know, maybe this is just not the right time to file. I mean, you're able to work full time. Yeah, James. So if you're not currently represented by a lawyer, you'll have to order your records yourself. So contact your local SSA office and do it. So, you know, it's a shame they don't, you know, it's a shame. They've been able to email these things forever, and they really put their foot down. Sometimes they're just too lazy at the field office, and that's something that hopefully will change with all this, like, do your job business or get out. If one loses, this is Tommaso, if one loses disability due to a CDR and they have not worked in 7 years, do they still qualify to reapply since they have not worked in 7 years? I believe so, yes, because the time they were disabled and not working are not going to count against that tolling. So whatever they had left, they should still have left. It should be fine. And also, they could probably do an expedited reinstatement. Don't forget about that one. You have like 5 years after you're ceased to do that, assuming you're ceased for working, that is, I believe. Angela asked if she should even worry about putting a settlement she's going to get into a trust because I'm now working full time. Again, Angela, you're the stuff of the welfare that you're collecting, those income-based things, that's something totally different. I would have no idea what you should do with that. I don't even know those rules. I mean, there's thousands of such things. If you're only talking about Social Security disability, money you get from a settlement doesn't matter. If you're trying to collect welfare benefits from some programs and not let them count high resources you have, you have the resources, but you don't want it counted and you don't want it to be spent, and there's loopholes you can do, then you have to go research those, and which programs do you need that for? That's not me. That's not something she says, darn it, I feel like it was going so well. That's a shame because I can't afford rent and needed a full-time job. I had no choice. I get it. Already on economic plans, but this will leave me ineligible. This is true. But the bigger picture is you're able to do it. So be joyful of that. You found a job you are able to do despite medical impairments that most of us have when we're over 40. Yours may be far greater than that, and it might not be comfortable, but now's the time to budget down one way or another. Some people go live with family. Some people bring in a roommate of sorts to cut those bills so that a non-SGA job can cover those bills, along with maybe some savings and help from family if needed or whatever. But, you got to do it. The SSD is for the disabled, not the poor. The poor has nothing to do with it. That would be the welfare stuff you're doing. And sometimes people relocate. I don't know if you live in an expensive area. People are like, well, I like living in Bel Air. I shouldn't have to relocate. Nobody should have to do a lot of things. We should all be born princesses, but that's not reality. And sometimes we have to move to a different area where things are cheaper. It could be rent is cheaper, that kind of thing. So what else, guys? I think we're good. Are we good? Do we have more questions? We do, sorry. Chewy says, I'm autistic and applied for SSI and they're sending me to a CE. Is this a good or bad sign? Well, the best sign would be they don't need a CE because your records are thorough and good and show that you are disabled if you're disabled. It is, so it's bad in that way. But what's good about it is they do it. They're like, hey, well, records aren't sufficient. Maybe she is disabled, but those things aren't showing it. Let's give her a CE and see what our doctor thinks about her capacities to do various work-related tasks. Shub, did you tell me this before, Shub? And I'm saying it wrong like a shrub. Sorry, Shub. I like Shub. I like Shub better than Shub. Shub. That's better. Okay. Rift. I have DDD. That would probably be degenerative disc disease and osteoarthritis and spine bone on bone in both knees and hip osteoarthritis. I am 58 and wanting to file, but I'm worried I will get denied. Rift, why don't you go to joydisability.com, go to the look up, and there on the left-hand side, it says free SSD evaluation. It will come to me. Mention in your narrative that I told you what your screen name is and that Stephanie told you to do this and that she would contact me and they will send it right to me. I'm a little bit behind on these things and I apologize to some people here who did that last week. And I know a couple of us are playing phone tag or email tag. I'm making phone calls today and I'm making phone calls tomorrow. So it should be good to go. I will probably just reach out and call you and hopefully get you, if not your voicemail, and we can play a little tag, but we will have a conversation about your situation and whether we can represent you. And if we can't, things that you might want to strengthen up on. And sometimes we have category blocks, guys, because they're full, particularly the ones where there's like gazillion people at any particular time who can't get a lawyer, who want one. And we take those, but we can't take all of those because we do need to keep the lights on. All right. So Rift, if you do that, I will definitely get back to you without a doubt. Okay. June Hagen, 75 years, woman, car totaled, Medicaid not covering. Medicaid doesn't cover cars, not covering because of 6,000. I don't know what COB and R letters are. No settlement received. Cancel or dismiss it. Appeal to Medicaid. Send check from attorney to mechanic, spend down necessary. Okay, not sure of the question there, June, but I hope you weren't hurt in that car totaling. Hope you weren't in the car or not hurt. I really don't understand those facts. I'm sorry. Lisa Gilbert asks, are you saying that only medical evidence within the 9 months between onset and DLI counts for one purpose? Yes. Even in a long, progressive, ongoing major depression, anxiety disorder. In general, I've not left my bed in years. Okay, so let me reiterate this. They have to find sufficient evidence between your alleged onset date and the date of your DLI to show that you are disabled in that time period. Let's say you have no evidence. That's a big gap. Let's just give it as an example. And I know that's not true of you, Lisa. I don't think so. They have to have enough in there. Now, how they interpret what's in there can be affected by what's been going on for years. Yes, for sure. So that's why you don't want to not get that stuff, but understand that if that's all you had, you probably cannot prevail. Because as of 2021, if you stopped treating and went about your way and never treated again, or took a big gap, that can be difficult unless the adjudicator, and this is more apt to happen with an ALJ, I think, there's evidence of why, you know. And sometimes it's just that you're like, screw it. You're so depressed, you're not out of bed and you're not treating, right? I know, I see it all the time. So it can be a little different with mental health. However, they need to show current disability. They need to show that you were disabled before you became uninsured. And if you weren't disabled before 2021, I'm sorry, between, what'd you say it was? Your alleged onset date was 2021 for whatever reason. Why is that your alleged onset date anyway? Because you said you hadn't really, because of that self-employment, that you didn't make any money at. Why is that your onset date? Just curious. So the stuff, but if that was legit, numbers you gave me, those dates, the stuff from before can show progression. But if you don't even say you're disabled until March of 2021, then that stuff back then, you already said, I have an impairment, but it's not disabling. And then there's nothing to show that it got worse before your DLI those last 9 months. Do you see what I'm saying? If there's nothing, no, if you have the really strong evidence that suddenly you were in crises and this and that and everything else, and it's indicative, then it's possible. But there has to be something. Or is that, why do you have that March of 2021 date? Is there something, I mean, even if you were doing your business, you could still be disabled. You weren't even making money. And if your hours were low enough that you were contributing, or, you know, that the productive hours that would be worth something in the general market if you work for somebody else, you know, maybe that you picked a bad deal. Alleged onset date, I don't know. But those are really important questions that you need to look at, perhaps, okay? And the history is very important, particularly when you're in a predicament you're in. You're going to have to get them. I'm just telling you that they have to find that you were disabled during that 9-month period, because that's the only period you gave them to say, I became disabled here. Okay, show us the evidence. And you can't say, well, 5 years, you know, look at that. 2 years prior, I was depressed. And I'll bring this up too. This is probably for everyone else more than you, Lisa, but in general, I've not left my bed in years. Is there a medical record proof of that? Like, is that something you talk about with your therapist? And do you have video hearings where they know you're in bed for years? And that therapist can be like, she doesn't get out of bed. Normally when people get that depressed because it's life altering and it's miserable, they get themselves impatient because they want it to be fixed. That's how bad it is. It kind of shows that it's not like pleasure life. It kind of differentiates garden variety depression or someone claiming versus severe, you know, to show it's actually severe versus I just don't want to work. You know, you have to have evidence of something more than garden variety depression, because believe it or not, most people at work probably have garden variety depression, and many of them treat for it, but they're still able to work full time. So you have to differentiate what separates you from them. Why should the DDS, what evidence shows that you're different from those people? You see what I'm saying? Tina, you're welcome. Tina says she overshares and truly always seem okay. I get it. There's a lot of people too. This is a little separate concept about this. There are people that can be in big pain and they are the most cheerful, nicest, kindest. They just have the best demeanors and character and presentation, because that's just their nature. And they are horrible when they're alone. They go back to bed or whatever due to pain. It reminds me of, even though it's not related, but this is maybe the kind of person that does this. It might have been me when I was little, probably less so now. But when I was in first grade, I had a stomach ache and I told the teacher and she sent me to the nurse. And I was a very smiling kind of kid and very precocious and stuff. And can you imagine that? And then the nurse sent me back. Now, I remember we had what we called rubber on rock for lunch in the cafeteria, which was grilled cheese with a side of stewed tomatoes, I think, and pickle chips. And I loved the pickles. So I ate. I don't know if I ate and then I got sick and got sent to the nurse or whatever, but I know I had that lunch. She sent me back just thinking I was probably just being dramatic or, you know, making it up. I'm a little kid, you know, and maybe I wanted to go home for some reason. And then I puked all over my desk. And so my teacher sent me back to the nurse and she sent me home, and she had a big apology for my mom, saying I didn't believe her because she was so smiling and she's saying she didn't feel good with this big old grin on her face. So I think a lot of people do that. And I know a lot of people who are not filing for disability yet, who are working physical jobs. A lot of them are like the blue collar, building America kind of jobs, they push through pain and keep working long after people don't, and they don't complain about it. And I have a lot of clients where I'm like, listen, from now on, I go, no, it's not your nature, but you have to be complaining to your doctors about all the aches and pains. You have to be the hypochondriac you never were. And I don't mean hypochondriac because you're just telling them the truth, but it's going to seem like hypochondria to the person because they're like, oh my God, well, that back that makes me hunch over, that's bad forever. I it's just irrelevant because I still walk, or, and they just, it's a work ethic, it's a character ethic, and it's not something you want to continue with during disability. You can do it with your friends somewhat. Some of them, I hear some people that say, well, my friends don't think I'm okay, whatever. But you have to start being that. You have to be more expressive to your doctors in particular and not doing all the things you did that cause you pain. You just have to kind of put on a different presentation of reality, because what was before was kind of a facade, right? And now you need to have the real thing showing in order to prevail in your claim. So sometimes it's a hard thing for people to do, to start being the complainer. It really is. The workers, that's the way working people are. Okay. Maeve says that ongoing care is in rural life. Yeah. Nearest Cairo takes insurance is 46 miles away. Driving an hour each way is more harmful than adjustment is useful. Had to move, I get it. Had to move to sister's home, no income in LA. Do they get this? They do, but that still doesn't create evidence for you. It just doesn't. And by the way, a Cairo is not an MD or a DO, and that is not going to be able to establish a diagnosis made. That can be the gravy on the cake. But if you're going to want an orthopedist with physical therapy, and the orthopedist you don't necessarily see 3 times a week like a chiropractor, or once a week like a chiropractor. So maybe it won't be more harmful than good by going to, you need to have these MDs to get the diagnosis, and then the ongoing. It doesn't mean the chiro isn't useful, but PT is usually prescribed. And if you want it to be considered medically necessary, it will have to be prescribed. Chiros have a lot more credibility than they used to have, but they have not risen to the measure of being able to diagnose for SSA purposes. I can't speak to anything else. That's probably more state-related evidence. Remember, when you say, do they get this? Of course they get this. There are people that are too poor to get treatment too, but that doesn't mean you win your case because you're poor and don't have treatment, because some people just don't have treatment because they're not impaired. So how do you differentiate yourself from that person? And that's where going to that orthopedist, getting the x-rays, the MRIs periodically, I would say annually on the MRI if you can, is what will fill in that gap. Physical therapy, I like because, and again, that's going to be difficult if that's, if there's no PTs in your area, which stinks. And no income. I hope you have, did you file for Medicaid in your state? You're going to want to do that. If you haven't done it, at least that'll get you your health coverage. You did mention you have health insurance, so I'm thinking you have something. And if it's Medicaid, that's probably why. I bet you there's local chiros who don't take Medicaid but take other insurances. And that's one of the problems with Medicaid. It pays so little to the providers that a lot of providers won't take it. And they won't take it, so there's fewer that do. And the people that need it are now stretched even thinner. So that's another probably thing based on some of the Medicaid expansions that made it harder for the poor, needy people to actually get Medicaid care. While some wealthier people are now allowed to get Medicaid, and they are kind of sucking up what should be going to the needy and the poor, disabled, etc. That's a political thing that I'm not pleased with. Umo, Attorney Joy, can you give me an example of filling out body pain and symptom diagram for PT? Can I give you an example? I don't think I can do that right here because we're in a live Q&A, but no, you can go in there and just read the directions. Come on, you got this. You can do this. The directions are right there. Just do it. It's coming to us, not to anybody else. And we know how to read it and ask questions, and we need to. You got this. I know you can do it. You do not need, well, I don't have a reference for you. So I have the form with the directions that are provided. Come on, you got this. It asks specific questions. You just give specific answers. That's all. That's it. And just, you don't have to give a book. You don't have to give a book. Grounded. Thank you. I suffer greatly and never leave, but I am a professional masker. Oh, just take the mask off with your doctors, okay? At the very least. Kosherish. Disability benefits are paid because you can't work, not because your life sucks. This is true, Kosherish. How much your life sucks doesn't matter to SSA, and nor should it, unfortunately. They're not the tooth fairy, right? Only whether you can work or not. Focus on why you cannot work. Kosherish, that was perfectly stated. That was excellent. Thank you. Janelle. Hi, Janelle Barrows. She says, hi, Joy. I called Social Security. They said the hearing office that has my case has 11 months to decide. It's been 7. All right, so you had your hearing, and it's been 7 months, and you haven't gotten a decision. And that's long. I forget, Janelle, do you have an attorney? What does he say about it? Has he poked the bear? You know, as an attorney, I would call the assistant of the judge. And if you don't have an attorney, you could probably do this too. And be very nice. Don't be, rude or, and just say, I noticed it's been 7 months since my hearing. Is the judge working up the file? Is there some medical evidence I should be submitting in my treatment? And by the way, you probably can't submit the evidence now, but it's kind of BS, right? And just say, can I submit new evidence? Because I've been treating like a dog these last months and a lot has happened. And see if you can get that latest evidence in because it's taken so long, and it might help the judge in making a decision. I mean, it's funny. They're probably not going to like that, but you're going to say it nicely. And, who knows? Maybe they'll say, yes, send up your evidence. Or if they've already made a decision to deny, maybe you don't want that evidence in there and you want to be able to use it for your next filing. So there's that too. 7 months is long. I don't think I've ever had a case that's gone 7 months without a decision. I might have seen 6 and it wasn't good. And also, is your judge alive? Did the judge die? Did it have to go to somebody else? These are all things that you could just ask to say, what, do I still have the same judge? And can I send up new evidence? Or should I just hold off because I know he's making a decision? Or just something to maybe get some insight, but always be super nice about it. Kevin says, this is a different Kevin, I think. I can't work from getting hurt at work, actually. Yeah, a lot of people that are on workers' comp are hurt so bad they can't get back to any kind of work substantially. Those are not the most favorite cases of SSD attorneys. I take them, but they're not. I kind of cringe when I hear this workers' comp because they really control your treatment. And then you can't get a lot of things you need to prove your SSD case, amongst other things. And they often get an offset, which that means sometimes we work for free with no attorney fee. M. Williams, yoo-hoo, just got off call, was approved. Very good. Glad to hear it, buddy. Thanks for sharing that with everybody. June, worth it to receive car settlement to repair car. Have attorney pay my mechanic. Small settlement, but cannot afford to jeopardize SSI, Medicaid. Well, if that settlement is going to be paid out and spent down right away, if it's that small, then you're going to lose 1 month because you're going to spend it the month you get it. And you're going to be below the $2,000, right? Is that right, June? You can use a piece of it for the rent for that month that you don't have the SSI, so hold off the amount for the rent and use the rest to pay the car, maybe? Just throwing ideas out. Every case is different. COBNR, that must be some state label in your state for maybe car accident cases. I don't know. It would be nice if the settlement order said, because this could make a difference. I can't swear by it, but it might. The defendant's insurance company part of the order is to pay the mechanic directly, as opposed to the lawyer doing it, because it's actually a check made to you and the lawyer cashes it. So it's still, that could maybe not work this way, but it's possible, and I'm not sure, that if the insurance company cuts a check right to the mechanic and not to you, for you to pay the mechanic, or for you and then your lawyer, then it might not count at all. Something to look into. I can't say, whether it is so. It's just an idea I would be looking into if I were you, or if I was getting paid $10,000 to represent a person doing this, so I could take the time to do all the research and dig deeper. That's something I would look into. Justin, you. Hi, Stephanie. How's it going? Holding pattern for me. I bet it is, Justin, you. Keep the patience. Okay. Catherine. Catherine got approved May 2025 for SSDI, filed in June of 2024. Not too bad. Spoke with someone in local office yesterday on the SSI wasn't approved due to more on SSD. Woke up with a deposit from back SSI. So the SSI was actually approved, Catherine. It's just that, and they paid it because you just said you got deposit from back SSI. But now that for the month that the SSD starts, you will not be going forward eligible for SSI. And when the SSD portion is determined what that back pay would be, it will have subtracted out the SSI they just paid you. If you meant back SSI on this, and that wasn't a typo. Yeah, because you would get the SSI for the months you had no SSD if you were poor enough otherwise. And then after this, the 6 month, after 5 full months of waiting period, now your SSD kicks in. Those kind of maybe have a retro, depending on when your established onset date is. But that's all good news. That's excellent. And it's good. It's good that you don't have SSI because you get more on SSDI. Really. SSI is a great safety net when someone doesn't have other, but it is a bit of a thumb on the pulse of your neck. Or maybe it's a kneel on the back of your neck. I don't know. It's very controlling, as well it should be. And that's why it's so great to be able to take measures to get off of it and get onto SSD because you worked and paid for it. James asks, now James doesn't have a lawyer, right, James? But James is interested in getting his file so he knows what's going on in his case. He's on reconsideration. If I'm saying this, recalling this right, yes. Right, James? Will an attorney be able to pull records from both the initial and reconsideration if he gets an attorney? Absolutely. The whole case. As soon as they get connected to the case, James, if the SSA does its thing, and sometimes it's very slow, and connects it to the electronic file, the attorney can get right in there and see everything. And they can download it for you too. That's what I do when people ask for it. All right, let's see. Catherine and M. Williams are talking about how they feel like they're in a dream because they just won their cases. I know, it's got to be. It's just a little life altering, Catherine says she's scared to spend $20 from her back pay. You've probably been tight as a nun's something or other. What is that joke they say? Frugally over these last months, right? Not having income and such. One thing I'll always say about back pay, guys, depending on the size of it, even if it's not that big, if you can live without spending it, you can do things with it. If you're SSD, you can do a lot with it. I mean, if you're SSI, that's not the same. SSD, you could start a little investment account with it, with some safe stuff and watch it grow. You can, if it's bigger, you can pay down your mortgage if you have one. You can buy a little tiny place you can afford the carrying costs of with your SSDI income, or if you have family. There's so much you can do besides just tinkling it away. As a person who's not disabled, that's how I feel, if I can get ahead with a little bit. I'm like, I gotta pretend I don't have this and put it over here and make it grow. And because nobody wants to be paycheck to paycheck all the time. And when you see that there, and particularly if you have a family or kids and you want to leave them something, or there's so much you can do with it. Buying real estate, if you could do that, is amazing, I think. Let's see. Daryl Smith says, can you switch lawyers if your lawyer is not communicating with you? Would you be able to talk with me? Anybody can cancel we have videos on this, guys, that explain everything about, the pros and cons of getting rid of your lawyer. Anybody can terminate the relationship at any time, the lawyer or the claimant. But the claimant getting a new lawyer, it can be tough because the old lawyer has a right to file a fee petition for a fee. And now the SSA has to divvy up. Both people will now have to do a fee petition. That whole $9,200 fee cap and 25% business no longer applies once one person has to do a fee petition. And some lawyers won't come on board if there has been a prior lawyer. We think long and hard about it. It's got to be, kind of like particular criteria and reasons, because we know we're not going to be able to get a full fee. And a full fee, by the way, we know we can't get it, even if the case goes on for 5 years and we put in, $40,000 worth of work. We can't get, the $9,200, presumably. Now, the $9,200 is what we expect, is the maximum you would get on a contingent fee arrangement. That won't apply anymore. In fact, it's much higher. The cap actually is much higher when it is fee petition, probably because there could be multiple lawyers needing to get paid. The prior lawyer, Daryl, is probably going to want to get paid depending on how much work he or she has done, and be able to ask for that money for the SSA to approve a fee on that. So it can be difficult. If you want us to look to see if we could be in the wings, should you decide to do that, fill out that free SSD evaluation at the left of your screen at joydisability.com, and it will be looked at. It won't necessarily result in a conversation with me, depending, but we will look at it and let you know one way or the other. Okay. Your lawyer's not communicating. It's very frustrating. That is one of the biggest bar complaints I've ever heard of since I came out of law school, that, attorneys failing to be available. No messaging, no this, no that, no returning calls. It's not that they have to return a call, but then they have to have another way of communicating with you. Someone has to there has to be a reason. I mean, if someone's being unreasonable, like asking questions every day, obviously they don't have to, but, by and large, there has to be a reasonable level of communication. And that is the biggest bar complaint I think that bars get. I think these people are not using it. If they don't have a portal, they should. It's affordable for solo practitioners even. And if they have it and they're not using it that way, then they're really dropping a ball, because it is incredibly useful, incredibly useful. But that all said, the lawyer only gets paid, Daryl, if you prevail. So I'd like to think that he's doing everything behind the scenes, except with maybe communicating enough with you to get you closer to a win, because he can't get paid without it. So all the work he's doing is for nothing anyway. And who works like that? Lawyers generally don't. So that's all I can say. If you're feeling insecure about him, he's probably doing a good job, and he's just not letting you know about it, which is unhelpful. Okay, I think this is Angela, because it's a flat line, which is good, Angela, particularly in this instance, right? Your Angelos are amazing. Oh, and thank you so much, Joy. It is, quote, understandable, unquote, to see if it is a successful job attempt past 6 months before I consider it over SJ. Oh, is it? It's technically, the rule is technically, I'll repeat it again, Angela, that you're supposed to report any work to the SSA when you're doing it. They will eventually find out about it, but they don't get those reports in real time. So whether you're comfortable violating that rule, that's in your hands. The rule is you're supposed to report it when you're doing it, when you make a claim. The paperwork told you that. Do I see the beauty of waiting to see if it goes past 6 months? I do. And I don't know that I almost want to ask colleagues what they think about this, because like I said, it has happened. And I know with that one guy, it worked out okay, but he wasn't over 6 months yet, but he had never reported it. And of course, my duty is to say, we've got to report this. And it happened to be simultaneous with when he got awarded. So it was kind of somewhat easier than the situation you're in. I just got to tell you what the rules are, okay? So tread cautiously. Oh, we're over 2 hours. Okay, here we go. Let's see, where am I? Kevin Johnson saying he got Marsha Blackburn. Okay, in Congress. Senator, I think she's a senator, right? Blackburn. I love her. I see her all the time. It's not congregation inquiry, it's congressional inquiry. It'll be 55, 59, and it'll be 16 January. I forget what your issue was. Was it a really slow case, Kevin? Is that what it was? Anyway, how cool is that? You probably have a signed letter from her and everything. I like her. She's a cute with her little, I call it a Southern accent since I'm from the North. It's really sweet. Trish Wade. So nice, Trish. I forgot to say thank you for all your videos. My husband did get approved with changing onset date to when he turned 55 in March. Yeah. I just got a notice of a win on a case on recon, and I'm very grateful. Very, very disabled lady. And I think they gave it to her, a 55-year-old onset, and that was a month ago. So I'm not going to be paid for about a year and a half of work. And I'm not going to do a fee petition and try to get the SSA to award a fee that she has to pay on a payment plan to me. I'm just not going to do it. I'm just going to eat it, because I'm very glad she won. And she's not a person with a working spouse who could afford to do anything more than that. There's going to be no fee to speak of, because her onset is March 31st, 2025. I disagree with them. So then the question is she going to want to appeal? I probably wouldn't even suggest she appeal. I think she's just turning 50. And I think we had kind of planned our dates so that this thing would be alive when she turned 50, because we applied earlier so that she would be able to get it. And I kind of knew I wouldn't get any. I knew it was a big risk of not getting any fee for quite a bit of work done over these years. But sometimes you just got to do it, right? So I had taken her case knowing that she was going to be able to win with the proper workup, probably at the hitting of the 50. So we did that when she was 49. And yeah, so I know now I know they did, if they had even waited like 6 months, I'd get a fee of some kind. but they didn't. And it's 6 months earlier for her, which is good. And it's just kind of something that we eat, I eat it anyway. I don't know. Some lawyers probably do the fee petition and bill them for it, but I'm just not going to do it because I don't want her to have a bill. She's not a wealthy person. She's a single person relying on family, very deserving person, and I would say poor. So she's not getting a bill from me. All right, next. Oh, it's Trish again. If he was already working part-time and noted in ALJ notes, does he need to call to report working? I'd say no. It's already been reported. If he changes, like let's say he steps it up. If he's working W-2, it's not the biggest deal because they're going to get those reports. It's when you're self-employed that it's more suspect and you have to be really on top of your stuff. I think they say if he changes jobs, because they're going to want to look at the nature of the job to see if it shows improvement and all that. Those are things that would trigger a type of CDR. Not necessarily to be afraid of. It's the logical thing they have to do. Oh, he changed jobs. Wow, let's take a look at the job because it shows what he can do. Oh, looks like my Mac is going to die. Well, we're going to get getting off here. I guess my dog goes under the desk and bumps my cord. Those Macs have those big blocks, and I don't want her in here under my desk, but she does it when I'm not looking. She's a big Bernese mountain girl, needy as all get out. Oh boy. All right. I think, do I have one more? If it ends up dying, it's just my computer that just died, guys. I think that got kicked out. Elliot Franco, I'm going to pull you up here. I know we're past time, but I don't want to leave you hanging. Just wanted to tell you Social Security came in last week. Oh, that's awesome. I'm very happy for you, Franco. Elliot, that's really good. Elliot Franco. I love that name. It's great. Good for you. See? Patience, right? Me and sugar. Hey there, I'm wondering why SSA went into my daughter's SSI info and changed my mortgage payment up $200 higher a month. The SSI people can't change your mortgage payment. So I'm not sure what you're talking about. The claim handler did this on his own. It's not true. I don't know what you're talking about, so I can't really answer, me and sugar. They cannot change your arrangement with your mortgage company. So whatever your mortgage is, it is, right? So maybe you're miswording that. Beth Prince is sharing. Am I still in, guys? I don't know if I'm just curious. That totally just turned off my computer. Is it possible I'm still in here like this? Even still? That's really funny. Answer me if I'm in there, guys. There's still a lot of questions. I was saying, I think you guys can still hear me. It says I'm still alive, I think. James, you don't need an attorney to pull your file. It's a 3288, which I had mentioned before, guys. I don't know, Beth, you may have had great, quick results. A lot of times people are not getting those great, quick results. I think that's part of the problem. But yeah, we had mentioned the 3288. That is the form you use. And then you got to kind of stay on top of it. And sometimes they try to charge people, which I think is very inappropriate when it's a program purpose, after all. And I will add, when Beth is talking about under number 9, put entire file, including initial DDE, examiner notes, etc., and email it to you. They have a statement in there that is incorrect. Beth isn't incorrect, but the statement is. It says, you can't ask for the entire file. Now, with the 3288 that I have, and I've shared with people who have asked for it on here, there is a POM section that specifically says, you can't make the person pick and choose, if they want the whole file, they can basically get the whole file. So I actually have that verbiage on this generic form. I plugged it right in and put it in a big red box in their face, and attach the POM section that tells them, you can't do that. You got to give him his whole file if that's what he asked for. You can't. A person doesn't even know what a DDE is unless they know what it is. Like, how can you tell a claimant to self-identify each document in there that he doesn't even have a clue what's in there? It makes no sense. There is that. Anybody needs that 3288 version, just email me and I will shoot it up to you. Lisa's talking about before her onset, she'd been working her startup business, but wasn't making a profit. PUA 2020. PUA. My mental health poor, many doctors notes back to 2019 on meds by March collapsed. You might have made a mistake with your alleged onset date, Lisa. It might be that you could say, if you were working less than 45 hours a month and you weren't earning SGA, you could go back to when you last did work SGA, assuming the reasons why you weren't working more, or full-time or whatever it was because of your mental health and you have good documentation. So give that a thought. At least you're opening. You kind of unfortunately didn't get those credits to change your DLI, but you And you could always change that going forward. You know that, right? Meaning prospectively. You could even do it while you're claiming disability if as long as you're working under SGA. But you could change your alleged onset date because you think you were disabled from working full-time long before the date you said, even though you're working the self-employment business, if you were working less than 45 hours, that's non-SGA as well. And then all those documents are going towards, you've opened up the window bigger anyway, because you were talking about how great those records were earlier. Now they're going to actually be within your window, if I'm understanding you correctly. All righty, kiddos. Maeve says, no specialists in the area. Diagnoses exist, but not getting current care other than primary. How can you call today? I definitely need help. Yeah, I'm going to call you, Maeve. I'll call you. I'll call you when I get off of here. I might have to go to the bathroom and get something to eat. Let me break that down so I know it's the first thing I should do. Okay. Yeah, that's troublesome because you have to be willing to, you're going to have to go get this stuff, I think. I mean, could you win on a primary care? You could, feasibly. You have a lot of I don't know your impairments yet. Well, I think I probably have them, but I have to go refresh. And I'll have that in front of me. Yeah, you're going to have to try to do that. Doesn't mean you have to go every week, but you're going to have to probably get something better. Okay. Good question. VG Warren, nice to see you. Can you get a settlement from car accident on SSDI? Yes, you can. It's a wonderful thing. And then you can do great things like we were talking before about using it smartly instead of tinkling it away. Yeah, SSDI that's just like any other insurance in that sense. It's not needs-based. It doesn't depend on your income. So that's good. SSI, totally different story. T says, blessings, God bless, may it help relieve stress and help you. Well, thank you. I could always use a blessing. Yeah. I'm all into that, T. NC girl says, hi FLNC. Can a caretaker apply for benefits? I don't know depends what benefits you're talking about. Gray, odds of approval. You think I'm a bookie, Gray? Come on. Odds of approval, heart failure, strokes, memory and mobility affected, HTN over 55, mental exam next week. I'm not a bookmaker, but I think you could have a good case if you properly work it up. Yeah. Jay Oliver says, my SSDI claim is in step 5, I think. Why don't I have any mail from them yet from the SSA? What step 5 are you talking about? Are you talking about the sequential evaluation process because it's still with the medical workup people and they haven't sent you anything? Which would be weird. How do you know it's with the SS, the workup people? Or are you saying that silly little step 5 back at the field office or a non-workup office, which means nothing? If it's in step 5, it means they haven't gotten concluded yet, right? So why would they send you mail? Elliot asks, would I be able to move to Medellin, Colombia and live on $1,000 a month and put away $800 a month? If you're SSDI, which I think you are, right, Elliot? And if I haven't checked the list of countries where we can receive monies, some untoward countries we cannot, Social Security, United States Treasury isn't going to send money, US dollars, to some certain countries for obvious reasons. I don't know if Colombia is one of them. If it's not one of them, and you can find that on the SSA.gov site. If it's not one of them, sure, you gotta look that up. And fingers crossed for you. You can move where you want to move. Let's see. Gray. Oh, I already answered that, right, Gray? Marcus Wallace. I have a question. I applied for SSI in 2019 and went through the process and was denied at the SSA judge. Okay. I tried working for over 2 years, didn't reapply until February 2025, went for SSA psychologist. Okay, so it sounds like they sent you to a mental status consultative examination. That's good. And I don't know if you asked a question, so I will keep going. LC says, if favorable SSDI, is it a given that you get CDR no matter the case or only certain cases like how strong your disability case is? Do you get one after a certain age, like over 55, recon 6 months? Pretty much everyone gets a CDR. Assume you're going to get a CDR. And yes, people over 55 get CDRs. People over 60 get CDRs. The chance of being passed over despite a diary date for a CDR, I think, grows as you get older because your medical impairments may be the type that nothing did happen in the medical world to cause improvement, and it's not otherwise likely to improve. Age is a factor, I think, in the amount of people that get passed. Like they decide that we decided not to CDR you, so blah, blah. We'll see you again in a few years. And then that can happen over and over and over again. Or they can do a little mini with the short form. But you have to plan for CDR. And you can call them and they can tell you what they should be able to tell you once you win what your diary is, how many years or whatever. Step 5, Jay goes back and says, checking for jobs I can do in the economy. Well, what mail are you expecting? They're still working on your case. They haven't made a determination yet because they have to find out if you can do different, based on your medical records and their RFC that they've already decided, can you do jobs? So they're working on it. They're not going to get mail. Not a love letter or anything else, Jay, until they make a determination, okay? But anyway, you're close. Step 5. That should be pretty quick. Step 3 is probably is where they're collecting all the medicals and getting it all together. That's going to be your longest. That's where everyone's sitting and waiting. Gray says doctors and specialists all say he not able to work, so hopefully reports from them reflect that. Yes, that's hopefully they do. Marcus Wallace. Did we have a previous? Marcus says, if I'm approved for SSI, will they go back to the first time I applied or fresh start? If you're approved for SSI, it'll go back to either the date you applied or if subsequent to that is when they found you disabled. They didn't think you were disabled the date that you applied, and we're talking SSI here, not SSD. They will pay you from the date they found you disabled because you already had an SSI application in. So any date after that they find you disabled is the date. All right, now I think we are at the bottom, guys. Whew. All right, 2 hours and 31 minutes. Oh. All right, VG Warren, this is the last because I love you. Do you have to tell them you got a car accident settlement? Oh, wait, am I repeating that? You just repeated that, bud. All right, so we're good. I already answered that, so you're good. And no, it's okay. You can have a settlement like that. All right, thanks, guys. Thanks for being here, and I will see you next week, okay? Be sure to tune in at 9 a.m. for whatever fluff may be coming out of my mouth, and I will talk to you later. Bye, guys. Thank you for joining and taking a listen to this video. If you have any questions that relate to this or anything else with regard to Social Security, disability, retirement, SSI, etc., please do feel free to post it in the comments below, even if it's not necessarily related to this video. And I will see them. And if it's something I can do a video on, I will be happy to do that. If you are looking for representation in a current battle to prove that you are disabled, whether you have applied yet or not, and ideally, if you have not applied yet, that's when we like to come in and start from the beginning and do our wonders. You can go to joydisability.com, look up to your left, and there's a little link for a free SSD evaluation, and we will take a look at it and let you know one way or the other. If you are looking for a consultation, not representation, or you can't get representation for whatever reason, or it's a non-representational type of issue you need to review, you are more than welcome to order a prepaid consultation. It will be with me personally, and that link is on that same page, joydisability.com, but over on the upper right. Anyway, thanks for staying tuned, and I hope to see you every day, 9 a.m. with our little video shares or live Q&A if you want to join me live on Wednesdays at 1 p.m. Eastern Standard. Thank you so much. Have a great day. Bye-bye.